I think your repeat, Tabitha. Let me confirm what is the issue with Kisumu to see. Okay, we are not sure about their situation, but I think we will get started. They'll get us along the way. Any class rep in touch with the other rep in Kisumu? Please indicate to them that we are starting. Because I haven't. Yeah. Sorry. All right. As I indicated earlier, if you find any challenges with us, Desmond. All right, I'm trying to project. You can see the slides.
Yes.
Okay.
Yes, we can. Yes, we can.
Good. What we intend to cover today is the thought of nuisance. I hope I'll be able to control this. Mwangi, are you with us? ICT?
Yes, I'm here.
Okay. I can see face any challenges, just be on the standby so that because I'm trying to project and I'm trying to project and the difficulty will be on my end. Let me see. All right. You've probably handled other part of thought, but this we have allocated around 6 hours to 2 sessions. And if we will be able to cover it within this session, then Friday you may have an early weekend, but we'll see how far we'll be able to proceed with today's session. Now, just a volunteer from within the group. Kindly, if you are able to see the projection, read through these words from one of the prominent or famous top law writers called Fleming, and in his book Law of Torts. Kindly just read through the statement by Fleming, a volunteer.
Yes.
Proceed, please.
One's legal vocabulary are bedeviled with so much obscurity and confusion as nuisance. Much of the difficulty and complexity surrounding the subject stems from the fact that term nuisance is today applied as a label for an exceedingly wide range of legal situations, many of which have little in common with each other. Fleming's Law of Torts, edition page number 49. Thank you.
Thank you very much. It sounds a little confusing, isn't it? That it may sound a bit difficult if a legal term is drawing a lot of confusion in its own meaning, then its application becomes difficult. So while it may sound a little unpleasant, this statement, of course, is true. And based on those different definition and usage.
Excuse me, sir.
Yes.
There is a lot of echo in where you are, so I don't know if you can do it because I'm getting a lot of echo.
Echo in my environment. Could it be my location?
Maybe, I don't know.
That they may not be improved now. How bad? Is it something that will disable? Okay. I'm not sure, but let's see. I have pushed it in my machine, probably create some distance with my machine. You still can hear the echo?
It's not that much for now. It's better, but not that clear.
Okay, or I'm making a lot of noise. Maybe I will also reduce on my volume. Okay. How about the rest? Do you think you can bear the echo that it's complained about?
Yes.
For me, you're clear, sir.
All right. And then I'll try and take you slowly again. And so we are trying to understand the challenges that we are likely to encounter with the thought of nuisance in terms of its legal application. We are saying that if a term in its definition is not clear or it's not definite, then its application becomes difficult. And why we, from the statement by Fleming, we do agree there are challenges. And one distinct side of nuisance is, the regulation of the way land is being used. Okay, usually to protect the neighboring landowner from adverse impact on the value or the amenity of that particular land. There is also that social usages that we refer to in terms of every inconveniences that we come across, we term it as a nuisance. The echo that you are struggling with from my end is a nuisance because you're not able to get proper signals from this end. Again, will that qualify to be part and parcel of a thought that we are trying to look at? So basically what this statement predicts is it's just about the wide application that this term has acquired without necessarily having those wide application within a legal framework. Okay, so we will distinguish now what falls within legal nuisance and those other ordinary inconveniences that we come across in our daily encounters. Okay, so to start with, I want us to look at where the word itself came from, and derivatively, the word nuisance as its roots in Latin, nocere, or nocumentum. This is depending on their own part of speech, because other times, when it's in verb form, you may look at it as or spell it as nocero, noun form, nocumentum, okay, whatever form. That is not of importance to us. We're just trying to dig at the origin, where it came from. And converted to French means noir, and later nuisance in English. Okay, so just like the statement that we went through that brought out, or that clearly indicates the challenges that we may have in allocating a nuisance thought, a portion within a legal framework. Arising from such confusion, we have had different scholars defining or coming up with different definition of nuisance. I want us to look at a few and pick on what is relevant to us within the framework of syllabus. Okay, so can we also have a volunteer who can read through what Salmon defined thought to mean? Kindly, a volunteer.
I can read.
Yes, proceed, please.
According to Salmon, the wrong of nuisance consists in causing or allowing, without lawful justification, the escape of any deleterious thing from his land or from elsewhere into land in possession of the plaintiff, e.g. water, smoke fumes, gas, noise, heat, vibration, electricity, disease, germs, animals.
Thank you. We'll need another volunteer to read us what another writer by the name Pollock defined nuisance as.
I can read.
Okay. Nuisance is the wrong done to a man unlawfully, disturbing him in the enjoyment of his property, or in some cases, in the exercise of a common right.
Thank you. Another volunteer to pick on Stephen.
Stephen, anything done to hurt or annoyance of the land tenement of another and not amounting to a trespass.
Thank you. Winfield.
Winfield, unlawful interference with a person's use or enjoyment of land or some right over or in connection with it.
Thank you. And finally, by Clark and Lindsay on Torts.
Define nuisance as an act or omission which is an interference with, disturbance of, or annoyance to a person's rights used or enjoyed in connection with land. It is caused usually when the consequences of a person's actions on his land are not confined to the land, but escape to his neighbor's land, causing an encroachment and causing physical damage or unduly interfering with the neighbor's use and enjoyment of his land.
Thank you. Now, as many as we are, over 300 something, we are likely to have our own definition also, just like these scholars who have written books for years, experts in thought, not being able to agree on what exactly nuisance is. But again, we are able to pick certain elements that run through these different definitions by different scholars. Can we pick those elements, those bits of references they made to certain actions or certain property that now can be put together to form the very basis of what nuisance in legal definition can mean and be able to be placed within legal framework for a tort that can be pursued in a court of law. Any of those elements that you were able to pick from. How many are they? There are 4 or 5 definitions here from Salmon. We had the wrong of nuisance consisting of in causing or allowing without lawful justification the escape of any deleterious thing from his land or from elsewhere. Okay. In Pollock, it says wrong done to harm a man by unlawfully disturbing him in the enjoyment of his property. Stephen goes on to say hurt or annoyance of land's tenement of another and not amounting to a trespass. He's even giving us a distinction between nuisance and trespass. Wilfred again, interference. Can we have what we are able to pick from these various definitions by various authors?
So for me, I was able to pick that a nuisance can be both an act or an omission, that it has to interfere with the enjoyment of another person's right to land, and the act or omission that interferes with the enjoyment of another's land has to be not lawfully justified. So those are the 4 elements that I picked. That it can
be. Thank you. You have given a whole definition again. I just want an element that runs through each of these definitions. But again, you have given all the elements actually that I wanted, but I wanted you just to pick on just one mention this, so that if you are waking up in the middle of night and you see a thing or an inconveniences around you, you'll be able to approach legal, indicate it as legal nuisance or any other inconveniences that happen to us and that we erroneously or rightfully refer to as nuisance.
Can you say disturbance?
Disturbance.
A person's right.
Yes, disturbance or interference in some definition, they talk of disturbance, in others, interference. Okay.
Can we say land?
Land, good.
Unlawfully.
References to land, actually.
Unlawfully.
Unlawfully. Okay.
Given your right.
Indirect.
Okay, indirect. I am left with just one so that we show what we have. We have interference, we have land, we have, okay, unlawfully, but
right.
We want to use another term. Okay, I think the one that I'm looking for is unreasonable use. Okay, unreasonableness, interference, unreasonable use, and the subject matter is land. It is connected to land, not any other aspect of a property. Okay, but land. Okay, let's dissect this. These are the basic elements that run through the definition by those different scholars. First is that there has to be unreasonable use of the land, okay? And that unreasonable use indirectly interferes with the claimant's use or enjoyment of the land. Forget it. If you look at all those definitions, they may have used a different term to describe unreasonable, but it's just another synonym to depict the meaning of unreasonable use. There is reference to interference, disturbance. Okay? In some, they use disturbance, in others, interference. But that bit runs through all the definitions that we have looked at. And again, it is as regards the claimant's use or enjoyment of the land. Okay, one is interfering with another's enjoyment of land through unreasonable use of his own land. Are we clear on this?
No, I have a question. Does the use of the defendant's land have to be unreasonable, or can it be a reasonable use that interferes with another's use of land, or just the interference makes it unreasonable?
The unreasonable bit will depend, as we will look at in the next slide, on different elements. The unreasonable use, if placed in other contexts, may be reasonable. But as we will dissect it in the next slide, we'll see that certain use in one context may be considered reasonable, in another context may be considered unreasonable, and therefore interfering with the enjoyment of the other land. I was trying to reflect on your question. I don't know whether the direction I'm taking this answer is relevant to the question you had asked. That's why I paused for a minute or so. So I don't know whether I have responded to it. To the question you are asking exactly.
You have, I think it's as you say, maybe if we see like the cases, then I will understand where the unreasonableness comes from.
All right, the next slide is about determination of that unreasonableness. How do we determine whether in given circumstances, what you are doing as a neighbor is so unreasonable to cause the other neighbor or to affect the enjoyment of the other neighbors of his land. One is the nature of locality, where you are placed within that locality. An activity your neighbor does may be considered reasonable in one locality or unreasonable given a different setting. Okay? What we mean here is that, for instance, a simple example could be if you're undertaking some construction of a warehouse within an industrial setting, that construction may be considered reasonable if you undertake it within industrial area or a planned area where such activities can be undertaken. But place the construction of that same facility in a residential place, okay, it will be regarded a nuisance within a residential setting than it is in an industrial setting. Are we together? We have this case of Stark versus Brickman. In this case, it was decided that what constitutes reasonable use of one's property depends on the character of the locality, and that it is no defense that the plaintiff came to the nuisance. Okay, so attached to the question that you are asking now, you had asked earlier if a locality that you want to undertake your activity in accept the nature of the activity you want to pursue, then that bit will be considered reasonable. And if the same activity is not accepted in certain locality and you want to undertake within unpermitted locality, then it qualifies to be unreasonable. Okay, so the element of nature of the locality now enables you to determine whether what you are undertaking is reasonable or unreasonable. The other element is on the duration of the harm. Okay, the interference you are causing. Has it been, ongoing, or is a new thing that has occurred? Again, this depends on the kind of activity. Okay, in this case, the Crown River Cruises Limited versus Combozone, although the fireworks display only lasted for a very brief moment, it was held to be a nuisance because of the extent of damage that the fireworks did to the vessel. Okay, you will read through those cases at your free time, just picking on the idea that those decisions communicate. So the duration of the interference will also determine whether whatever you are undertaking is reasonable or unreasonable. For instance, in our setting recently, we had those Diwali fireworks, but you know how long it lasts, the noise it makes, compared to the extent of interference, cannot fall within the nuisance, legal nuisance, or the harm that can fall as a nuisance and a tort. Okay, that also you would apply elements like the locality within which it is being practiced, the duration of that harm, and all that. Okay, so the locality, the duration determines whether whatever you are undertaking is reasonable or otherwise. Next is on the sensitivity of the claimant. There are instances where what may be considered ordinary to a lay person, maybe to a few within us who are very sensitive, may be considered a nuisance. So these are very exceptionally delicate thread or even conduct of certain individuals. If you are too sensitive to even interact with ordinarily with your peers for one reason or the other, such instances may not be considered as being qualifying for unreasonable application on the other end. If whatever your neighbor is doing now it scares you, and you take that as a nuisance that falls within the realm of legal nuisance, then that claim is likely to fail if you are seen to be too sensitive in terms of, in relation to what your neighbor is doing, and of course, in relation to the extent of reasonableness or the extent to which whatever is being undertaken is considered to be an ordinary thing. Okay, so those are critical elements that you will need to identify for you to for even judicial officers to determine whether an act that is being undertaken within one's neighborhood is reasonable or unreasonable. Okay, any question? All right. The other bit is on the motive or the malice of the defendant. Okay, if the defendant's action interferes with the enjoyment of, say, the neighbor, just out of, say, being, out of spite, that defendant can, because for revenge purposes, you undertake certain activity, then that does not qualify to fall within the legal nuisance tort. Okay, so the motive or the malice of the defendant is critical to determine on whether what he then intended to undertake within its premises was actually intended to do certain harm on the neighbor, to revenge on probably disagreement on issues that they have had in different over different subject matter. Okay, so unless there are questions, we proceed to determining what constitutes interference. Okay, we are looking at those elements that we have identified in our definition. That is existence of unreasonable situations, and that unreasonable situation interfering with the enjoyment of the other's land. Okay, so next we'll be picking on interference, if there are no questions.
Question, Mwalimu, question.
Yes, proceed.
Yes, Mwalimu, thank you. I'm a student from Kisumu campus.
Yes.
But last week we had a joint class for Kisumu, Nairobi, and Mombasa campuses. But today we've not received a link, and the students from Kisumu are stranded. They don't even know whether they are supposed to, which class they're supposed to attend, because they have not been attended to.
It's unfortunate. I shared the link with your class rep. It's called Tabitha.
No, they haven't received any link, and so they are stranded as to whether the class has bounced. None of them is in this class except me.
How did you get here? How did you get the link? Can someone share?
No, I've just seen. Okay, somebody has just shared with me this link from Nairobi campus. So I've been able to join the class. I've been able to join this class, but the other classmates of mine in Kisumu are stranded.
Okay, I see. I shared with one Tabitha, who is a class rep from the Kisumu campus, who confirmed and acknowledged. I mean, so what can we do? Can we? You have the link now. Can you share?
Okay, let me do so, sir.
Again, we will have this class. We'll be able to finish this class in good time because we're just handling this on first and fifth. We can, if they are able to join now, probably they can catch up with us. We'll see how we can take care of them. We haven't gone very far. So, sorry about that, but again, I was not able to go through your class reps calls now, which is offline. How many class reps do we have on board? Mombasa, you are there? Ronald?
Yes, I'm present, sir.
Salome, I confirm you are there, Gladwell?
Yes, I am here, Gladwell, present.
Okay, so I shared with Tabitha also, she confirmed, okay. We'll see. Any question as we wait for Kisumu to come on board? Yes.
Could you please repeat the explanation for the motive or malice of the defendant?
Okay, any other?
Mwalimu, kindly repeat on the duration of the harm also.
So we can do it for Kisumu. We will also get it. Wangi, can you help Kisumu? Are they doing or Wangi is off now? Okay, we start with duration. Okay, you said duration and the motive or malice of the defendant. What's true? We are expecting close to 300 or 400. We only need to, if Kisumu joins, might have a difference. Okay. Now, the duration of the harm, we have that case, the case of Crown River Cruise Limited, that explains, depending on the nature of the activity, the duration, regardless of the timing of the activity, may qualify to be reasonable or unreasonable. So the nature of the activity comes in for determination, and the impact of that activity comes in for determination, because there are instances where the longer the duration, the more unreasonable the reasons become. In other times, regardless of the duration, and in this case, we have the Crown River Cruise decision that covers, however, short that period is, if the impact that that activity has had on the claimant causes certain elements that we look at, like distress, general harm, then that activity qualifies to be considered unreasonable and therefore may be falling within the legal torts that can be whose decision may result in remedies for the claimant. Okay, so basically, ordinarily, the longer the nuisance, the more unreasonable it's supposed to become. But again, the nature of that nuisance or the nature of that activity may make it, regardless of the time or the period, may make it to be unreasonable or qualified to fall within legal nuisance based on the impact that it has had on the claimant. Are we communicating? I'm not sure whether it is clearer or we've just added more confusion. Hello? Or there was no question on that? Are we all together or have disappeared?
It is okay.
Get together.
Yeah, okay. Then we move to, there was question on motive or malice of the defendant. Here, if the defendant is being a nuisance out of other ideas or other reasons, okay, revenge purpose, whatever purpose, that is. So someone is talking. That this person is undertaking this activity to revenge. And there's a lot of echo in the background. Please make your.
Excuse me, sir.
Yes.
I have a question on these elements. So do they have to exist as a unit, as in must all these elements be satisfied for something to constitute unreasonableness, or if one exists then nuisance is perceived?
Good question. The one will lead to the other. Okay, if these elements an unreasonable activity leads to interference, automatically it leads to the other. Then, based on the facts that is placed before the judicial officer, you will be able to determine to what extent a nuisance has occurred. Therefore, they are important in determining whether, in actual fact, a nuisance or an activity that qualifies to fall within that category has occurred, and to what extent remedies can be addressed, or the claimant can have a cover for the damages that has, out of those interferences, have interfered or has affected his enjoyment of his land or property. Okay, so they are critical. Existence of one is likely to lead to the other, and the extent to which this goes to affecting the claimant now aids the judicial officer or the person determining the dispute to decide on the extent of compensation or recoveries that needs to go into assisting the claimant or the plaintiff. Are we together?
Thank you. Thank you.
Yes. All right. I guess you are satisfied. If you are not, then you will be again. Yes.
A question. You said that it's no defense that the plaintiff came to the nuisance. Can you please explain that?
Sorry?
On the nature of locality, you said that it's no defense that the plaintiff came to the nuisance. Explain.
Okay, there are times when if you move, maybe with an example, you move your locality and within that locality, the nuisance or the activity, the unreasonable activity is being undertaken, and you get affected by that nuisance while you are in this locality that has been affected by the thing or the thing that you will use this term later on, the noxious thing. When we look at the case of Fletter versus Raylan, if this affects you, it does not really matter whether you are within your locality or not, okay, or whether you are within the locality of the nuisance or not, provided you are the result they look at is the harm that have resulted from that activity, regardless of sorry, let me, the Kisumu people are calling, let me just receive this. Sorry about that. There's so much confusion now in Kisumu. How many are on board now? Kisumu, are you here? Apart from the earlier entry.
Yeah, I'm just joined now.
Or you are quite a number now.
Well, I
Tabitha is your class rep. Can you confirm if Tabitha is your class rep? Because this link was shared with one Tabitha. So we need to sort this out once for all, and so that we don't get it repeated elsewhere. This is directed to Kisumu because we are getting calls from lecturers also. Can we continue to use Tabitha's contact to send the links to Kisumu? Can I get an indication that that is the class rep? Okay, can I be heard?
Yes.
Still a call.
Yes, yes.
Okay, I take yes to mean Tabitha continues to be your rep. Okay.
Tabitha is not our class rep.
All right. For the rest, I think apologies because this has.
Tabitha is not our class rep. Tabitha is not our class rep. Believe me.
Let's have your mic muted. What it means that there are instances in thoughts, different thoughts, that the term we use is volitional injuria, okay, where your presence may be considered to contribute, I will not say as a defense as such, but as a mitigating factor to some extent. But for instance, yes, please mute your mics. Okay, there are instances where your presence, with regard to what caused a particular thought, matters. But in this case, we are saying that the claimant who is injured or who is harmed, his or her presence at the time really matters not, provided that harm has occurred. That is exactly what coming to nuisance with regard to defense within nuisance means here. But I want you to look at that case in detail, look at the facts and the reasoning of the judgment finally. But the use of one's property, here we have placed it under nature of locality because part of that decisions talks about use of one's property having to depend on the character of the locality we are giving example of warehouse construction within an industrial setting vis-a-vis residential setting. I still hear some noise in the background. Kindly mute your mic. One if you have one, please, you can mute them. Okay, where are we? We now proceed with the element of interference. Are you there? I hear a lot of noise. I am trying to figure out from where. If you are seeing the notemakers, just mention to them that they need to mute themselves.
Mwalimu, can you hear me?
Yes, I can.
This class has normally over 300 students, and sometimes we have people who can't mute. So you just continue. That's how we've been surviving. It's so unfortunate, but that's how we've been surviving. Thank you, sir.
That's one way there. We have I hate part of God. I don't know whether you have left us alone. I think you should be able to meet everyone. All right, so can we then continue with those elements that constitute interference?
Excuse me, sir.
Yes.
Okay, before you move on, actually still on the issue of malice. Can someone therefore be right to say that in the total
Desmond,
defense conduct is a relevant factor for the court to consider in determining either the reasonableness?
I have missed part of your question, so please you can recap again.
Oh well, I was actually asking, would someone now say that in the thought of nuisance, the presence of malice or bad intention in the defendant's conduct can be considered a relevant factor in case of any nuisance case that has gone through a litigation in determining either the reasonableness or the unreasonableness of the conduct that was causing the nuisance, and consequently maybe the liability, the tortious liability of a defendant in the nuisance case?
Yes, we will see it later on. Actually, nuisance falls can fall within both criminal and civil acts. Okay, so and in criminal law, of course, determination of existence of mens rea is the requirement, and therefore it depending on the act. Okay, it may be a primary factor for consideration, especially if it amounts to a criminal, let's say, nature nuisance.
So I have a question.
Excuse me, sir. So in some instances, malice is evidence of unreasonableness on the part of the defendant and the vice versa of it. Yeah.
Sorry, I'm trying to.
Okay, so in some instances, in the thought of nuisance, malice is the evidence of unreasonableness, or the absence of malice can be the evidence of reasonableness on the part of the defendant.
It's an element you may consider. If you go on a revenge mission, then you may not have a course of action to pursue. Okay, in the example we gave. So that is a critical determinant. What you intended, is it driven by your desires to hurt the other or to harm the other? Was this preconceived? Did you have a prior or a conceived intention to undertake the harm that you have caused to your neighbor? That if that element exists, then it qualifies. Desmond, are you okay? We pick another question.
Yes, sir.
Yes.
Sir, the last one. So what of the case of Christy versus Davy? Can you possibly maybe kind of explain the facts and how the court held with regards to the tort of nuisance? Yeah.
Which one?
It's even in the slides, the one of Christy versus Davy, because it's talking about the noise itself as the nuisance, but it actually held and was talking much about the element of malice and the reasonableness of it.
Yes, where the claimant, this case of the Fox farm, is that the one you are referring to? Yes, the claimant had bred some foxes for their farm. So the silver foxes were particularly very timid, and if there was any disturbance when they are pregnant, they are prone to miscarry. So in that case, now the defendant was the claimant's neighbor. He objected to the fox farm and fired a gun on his own land close to the breeding pens with the intention to just scare foxes and impede the breeding. So the claimant brought an action in nuisance and the defendant was liable despite the abnormal sensitivity, okay, because we are told the foxes were very timid, very sensitive, okay, despite the abnormal sensitivity now, because he was motivated by malice, he was found to be liable.
So I have a question.
Yes, Gobu.
In relation to this case, the Fox Farm versus Emmet,
Yes.
how do you measure the intention or malice? Because this person fired a gun in his own land.
All right, look at those five. Read through the entire case, you will be able to determine
Yes, the fact of the case actually were the defendant ordered his son to fire a gun on his own land, but as near as possible to the
those are very, yes, Gogo, those are very brief facts. Going into details, the neighbor has never wanted, okay, he has been objecting to the establishment of that farm within that locality, and therefore he had to look for ways of making sure that because of the impact of his activity, this farm will be wound up or even closed. So when you read through the entire judgment, you'll be able to figure out whether there existed malice or not.
Okay.
Not just brief facts, the entire decision. Okay, any other? Now we then proceed to look at what constitutes interference. These are very ordinary elements, okay, and I have listed them against determination by different, all cases, but still useful, still our courts use these cases to determine whether what is being complained of really has the element that may constitute a legal nuisance. Okay, so in noise we have Christie versus Davi. Here, the court granted an injunction ordering that the defendant stops making unreasonable and deliberate noises to interrupt the claimant. So they did not, however, stop him from making noises that are reasonable, a reasonable household may make. Again, a question like go proposed, what will that what are the measures, what are the benchmarks to use, whether these are reasonable noise within a homestead, these are unreasonable in a given setting, Okay, so all this will have to be defended based on the fact that you bring before the judicial officers. Okay, the emotional distress case, Thompson versus Schwab, Thompson Schwab versus Kostaki. This one caused them emotional distress, where the sight of the prostitutes and their clients entering and leaving neighboring premises were held to amount to an actionable nuisance, as the activity was considered offensive in itself. Again, this will depend on the locality that one is placed in. We have elements that constitute interference, like smell. Again, we have that case of Sanders. Okay, that explains when you consider such a smell emanating from a given activity as a nuisance or not. We have flooding of water onto claimant's land propagated by, of course, the defendant. This points to the Fletcher versus Freyland rule, which will cover under strict liability in detail. Okay. Any question on? We are now moving out of those elements that will enable us to determine whether a given scenario or activity may qualify to be a legal nuisance or not. And reasonableness, the elements within what you need to consider or what you need to pick out for you to determine whether an action is reasonable or unreasonable. The interference, what constitutes interference. We are getting out of this to different parts of nature. We look at. Yes. Someone is talking, but yes.
Your last point talks about flooding of water on claimant's land.
Please, I can't hear you clearly.
Yeah, that's not true.
Gerald.
Your last point on this. Can you hear me now?
Not clearly. Try.
Amas.
Yes. Proceed.
Can you hear me now?
Yes, better, but could be a network. Are you still on?
Sir. Yeah.
Proceed.
Your last point on the slides is it talks about flooding on a claimant's land. So I was asking, is that not trespass?
Flooding.
Yeah. Is that not trespass and not nuisance?
It depends on the facts again. Have you done strict liability? Not yet. The nuisance of strict liability. We have instances where a given fact may result in a number of other torts. Okay, you may have a fact that leads to a tort of negligence, similar fact leading to tort of nuisance, similar fact leading to trespass. Okay, but nonetheless, again, depending on what area of thought or the activity, the nature of that activity and the nature of the damage that it causes, then you'll be able to move with which thought is appropriate for me to pursue, which one has more ground to defend, and which one maybe just an ordinary inconvenience. Okay, so flooding of water on the claimant's land, in one aspect, can be said to be a trespass. When you look at the case of Fletcher versus Rayland, they say seeping of water into the grounds that affect the neighbors' enjoyment of land can qualify to be a nuisance. Okay, just the seeping of water, underground water. Okay, that qualifies. And they try to distinguish, which we will see later on, location of a strict liability, which ordinarily has been held as part and parcel of nuisance, and now standing alone as a thought of its own. Okay, so it depends on how the nature of that flooding again. Has it seeped into and affected the neighbor's enjoyment? Has it flown in so it can fall not just trespass, but also within the thought of strict liability? Okay, depending on the facts again. And that is what judicial officers do. What they analyze is what is placed before them qualify to be within the realm of this thought or this other one. It's for them to determine. For you, is to take before them what you perceive as an ordinary or a lay person based on the damage of what it has cost you again. Okay, to ask them to determine. Yes, okay, you're talking about. Okay, so basically, it depends on where the facts direct you to go. Okay, is it majorly on trespass? Is it majorly on strict liability? Is it majorly on nuisance? Okay, and all of them can result in one decision also. Okay. Yes.
So,
okay.
Sir.
Yes.
Sir, so I'm just asking, based on this statement,
yes,
flooding of water onto claimant's land, where do you place this thought? Is it nuisance or trespass?
Flooding of water on sorry, where are we? Based on this statement, I can place it on board, but for my case, we are looking at the elements within interference. Okay, And secondly, in fact, more than the trespass, I'll place it under strict liability under the rule of Rayland versus Fletcher. Are we together?
Yes, thank you.
Yes, if water collects underneath or above the surface, depending on now the damage that the claimant complains of. Probably the surface water may have not done much, but the underground may have contributed much of a damage. But as I indicated earlier, it largely falls within the realm of strict liability, which you will be dealing with in your subsequent classes, either with myself or any of my colleagues. Okay, can we proceed? So let's look at, yes.
Can somebody have control over smell?
Okay, yes, class, can you have control over smell?
Yes.
Yes, Cosmos, help us how?
Maybe one may be having a septic tank that is not has failed to cover the top, so the smell is diffusing all over.
It's minimized.
Sir.
Thank you.
Sir.
Yes, Joseph.
I think even though one may not be able to control maybe smell, maybe due to, maybe when it is sunny, the smell spreads all over. I think it may help the case if the person puts in place mitigating factors to reduce the smell and also make the environment better for the others. So even if the smell reaches them, provided he can show that he did his best to ensure that the smell does not reach them, it might help his case.
Okay, thank you. Okay, Joseph.
Sir, I have one question.
Sorry?
I have one question.
We are responding to I don't know who asked the question, how we can control the smell, and we have a very good responses. So
Yes,
can you respond to this answer, and then we answer you first?
It's a follow-up question.
Go ahead with us. We are not ignoring your question. Eh? What we are saying, we want to first dispense with the question on noise. And we're asking you to respond.
I think on the question of smell, I'm with the previous speaker that in tort law, in law or in tort law, if you create the nuisance, then you are expected to take reasonable measures to make sure that other people are not affected by it. So it's not that you can, does someone own a smell? Yes, if you created the smell, then you are the owner of the smell, and you are expected to take reasonable steps to make sure that it does not interfere with other people's enjoyment of their own land.
Yeah, precisely. I think all other speakers have pointed towards the action of the defendant. If we will not be able to.
Hello? Yes, message kwa nguvu juu imekataa kufungua but iko 1, naona iko 1 point something.
Are we being addressed or?
Sawa. Na natumia data but data unasikia inanyamaza. Kwa class inanyamaza. Unasikia kama sasa inaangi yani.
Okay. Yeah. Inakoma.
Inakoma. Natumia data so situmii net.
Wacha ndasort hiyo.
Taitumu mute. Well, so it points to the measures that the defendant normally puts in place. We are not able to control, of course, the medium through which the noise passes through. But again, those measures that you undertake in terms of are we on noise or smell? Sorry? Hello, you can hear me?
Yes, you can hear you.
Arike, you are speaking. I think there's an issue with your network. Okay, I hope the larger population has been. Okay, so we may not be able to control the medium through which this is transmitted, but as we will look at the defenses later on, the measures the defendants put in place are critical in determining whether he is at fault or whether he has interfered unreasonably or not. Okay, so we continue. Yes, Gobu, your question. You are talking about a follow-up question on the previous.
Yes, it's about smell. Maybe perhaps it's a scenario question. I go and buy pesticide and I use pesticide in my house. The requirement is that I use protective gloves and maybe a face mask. I adhere to that, and then out of that, maybe a smell leaks, and then my neighbor inhales it. So out of that, he contracts maybe a disease like cancer. Can he sue me?
If your neighbor is able to put together the facts and connect the cancer bit of it to the spray and all that, it all depends on the framework of those facts. Okay, how the causality, you will look at those causal links again. So there are many things that will come into play for you to determine or establish whether he or she will have grounds to go under nuisance or negligence in you performing your spraying activity or not. So the bottom line is the link between your action and the impact it has had on your neighbor. If you're able to establish, why not?
But assuming that that person has no intention or malice aforethought to harm his neighbor or her neighbor.
I think I was clear. We look at the facts. Huh? Okay, and if that malice afterthought, again, the claimant or the defendant is able to bring out with some clarity, you are at liberty to dispose of it. Okay, so what we are giving you the principles, the ideas, but the fact on the ground may point in different direction, and the direction you will take will be informed by the strength. Okay, the causal link of whatever you are undertaking and the impact it is having on your neighbor as regards now the total nuisance. We have mentioned strict liability aspect like the rail and plater rule. Okay, so if you are able to place this fact within the framework of any of these principles and able to prove it, then it's for you to choose which direction to take. Okay, any other question? We can go to the parties in a thought. All right, So who can sue? I hear we talk of persons with rights. Okay, any person who is entitled to exclusive possession of the affected land. Okay, that is one. And this points to the ownership bit. Okay, because you can only talk of you having rights on a property if you have a certain legal attachment to that piece of land. The other party who can sue is a reversion of the affected land. You know, any person who may not be having direct interaction or enjoyment of the land, but whose interest is affected in future or otherwise. And those with easements and profits from the land, if you are entitled to using part of that land to access, for instance, a public facility, also you will be able to sue based on the impact of the nuisance on your usage of those easements and the profit that you draw out of that. So you can look at the case of Canary. Okay. So this brings out who is eligible to sue and who is not. And the bottom line here is you must be a holder of certain rights as regards or that land, rights, interest over a given land that is being interfered with by the nuisance. Okay, so at your own time, I wanted to bring through the case of Hunter versus Canary. It brings out the difference between those parties who are eligible to pursue their interest in affected property, those who cannot be said to have any interest. It also distinguishes between what we alluded to in our introductory part. You cannot seek for a delightful thing through nuisance. Okay, so I will urge you to go through that case. Angela Mungulu.
Niliboost na laptop kiasi.
Muguku.
Ilikuwa tu sawa.
All right. Good. Any questions on who can sue? Now we look at who can be sued. Who can sue? Who can be sued? Okay. The person who occupies or controls the land from which the nuisance emanates, if they are responsible for those nuisances. Okay. We are putting responsible there because sometimes a tenant within a rental facility can be a cause of a nuisance, in which case the owner may not be liable. The occupier of the land who creates the nuisance is related to the first point. And again, the occupier of the land who authorizes the nuisance, sometimes the nuisance may be undertaken by a different party, but the authority behind it will be totally a different entity altogether. So the occupier of the land who knows or ought to know of the nuisance can reasonably stop it. Such a person also can be pursued. Okay, so basically that is it on the parties who can sue and who can be sued. Okay, we go to the types of nuisance if there are no questions. We have two categories of nuisance, and of interest to us in your current curriculum is the private nuisance. So we'll touch briefly on private nuisance, I mean the public nuisance also, but our focus when in your reading should be the category that we call the private nuisance. And it's not very different from the definition we have given earlier, or has been given by different authors in our previous slides. So private nuisance basically means an interference with an occupier's use and enjoyment of his land. Okay, you will see the element of interference coming in, enjoyment of the land. So nuisances are those interferences which are unreasonable, okay, which injures the property or causes some discomfort to those living on the property, and therefore liabilities are apportioned to the defendant that arises from using that land, now his land, in such a manner as to injure a neighboring occupier. There are two uses here. Okay, we refer to how the defendant uses his land. Okay, to now interfere with this other usage by the other neighborhood, who we most of the time refer to as claimant or the plaintiff in suit. Okay, and it's likely it falls under civil suits, mostly private law will be brought to court as civil cases, while public nuisance will occasionally, of course, we will have public nuisance having civil elements and criminal elements at the same time. So, but it's not much of our interest as regards to syllabus, but briefly we will look at each of it. So, what are the essential elements of a private nuisance? Is what we directly have looked at. Yes. Yes. Hello. I can't hear anyone. Okay. So, what are the essential elements of the rest? Can hear me?
Yeah, but before we go to types of nuisance, can I ask a question?
Please proceed.
No, there are times maybe in a plot you are staying with the landlord. Now, the landlord makes a private nuisance, and maybe it has affected the tenants, and it is his compound. How is he liable, or is there any way he can have affected the rights of those that he's staying with? Remember, the land is his and the building is his.
But your neighbors.
Oh, the landlord, like he's staying in the same plot. Let's say there are those landlords who stay in the same plots with the tenants, but unfortunately has created a private nuisance and it has affected the tenants. Now, how is he liable or to have created that nuisance? Can the tenants sue him?
It depends. Again, if you have that arrangement between the tenant and the landlord that is contractual. Okay, if part of if what you consider nuisance is part of an arrangement that falls within this contractual framework, it may be difficult, but you can proceed based on the nature of the arrangement that you have had. Again, in such a setting, of course, you are at liberty to vacate even such premises. But if in the contractual arrangement that certain things that the landlord does may appear to you as a nuisance, but to the larger group it may not be, you may proceed and persuade as an individual and establish whether such, based on, of course, the nature of the activity and the impact it has had on you, establish whether you have a cause of action to pursue or not. Was that? I don't know. Are we together? Again, the definition of a neighbor comes in. Okay, if what he is performing affects not just the tenants there, but the larger population, you can proceed under provisions of a public nuisance. If it's affecting the region, not just confined to the tenants, but it's just to the tenants, then first of all, the starting point is your tenancy agreement. Is there anything contained therein that will give this landlord a leeway to undertake whatever activity that in your own understanding is causing you discomfort? Okay.
Okay.
So if there are no other questions, we can look at those elements. That in private nuisance, the plaintiff or the claimant should have right to use or enjoy that land. Okay, if you have no right attached to a piece of land or are using that piece of land, then you may not have, you may not be able to bring claims for private nuisance. And again, the defendant should be doing, such a thing that is considered to be unreasonable, okay, to undertake on your neighbor, on this land within your neighborhood, right? And also unreasonable interference that results in damage generally. Okay. Excuse me. Sorry. So it emanates from you, the claimant or the plaintiff, having to possess certain rights to use or enjoy that land, and your neighbor, who is now the defendant, having to use its land unreasonably to affect your enjoyment, resulting in certain damage that you may require now redress before the courts of law. Okay, so this element of private nuisance has to be established for you to proceed to seek for any redress from court. So briefly, let's look at public nuisance. Okay, this one is just on the coverage. Okay, for public nuisance, it's an interference what is this popping up? Our IT people. Are you seeing my screen?
Yes.
It's just the notes.
Sorry? I decline. I'm not sure. Mangi. I think Mangi is gone. Okay, so an interference in a setting where public interest is affected. Okay, for private nuisance, we are talking of a private interest being interfered with. So here I want you to look at the English case of Attorney General versus PYA queries. So he distinguishes public nuisance from private nuisance. You will read through the decision at your free time. Within Kenyan setting, we have provisions under the penal code that provides for largely public nuisance. It even defines what nuisance is. Look through it's chapter 3. That section I have given up to I think 108 something. It talks about public nuisance through and through. The other law within our context is Public Health Act. Also look at the Public Health Act, the entire, I think part 9, the entire part 9 talks about nuisance of some sort and what constitutes nuisance. It also outlines large number. We've had counties coming up with their own customized county legislations or bylaws to manage or guide on how a nuisance may be controlled. And of course, you may have heard what Nairobi City County is trying to do in terms of the very small inconveniences here and there that we normally see on our city streets. They have tried to come up with this legislation to control nuisance. Some will fall within the realm of public nuisance, others private nuisance. But for such legislation, likely it covers or handles public nuisance. And at the national level context, we have in mind what this nuisance does for our environment in terms of environmental pollution, in terms of sewer systems within our urban settings, and for that, mostly for environmental pollution, you look at provisions within what we largely, what we commonly refer to as the EMCA Act, that is Environmental Management and Coordination Act. Okay, so for public, nuisance at that level, we have those different legislation that addresses different aspects of public nuisance within our setting. So I'll be glad if you find time to look at the whole part of Part 9 of Public Health Act to understand more what constitutes some of those public nuisance. Okay.
Excuse me.
Yes.
So public nuisance is criminal in nature.
Yes.
Thank you.
Any other? We go to defenses. Okay. We were supposed to have 3 hours. Huh?
Yes.
So I think you can choose to cover the whole thing and have an early weekend on Friday, or we can cover the remaining part later on. But that again is just it's Kisumu. Are you catching up?
Yes, Mwalimu, but from midway or from where we just found you.
Okay, we'll figure out where you found me, but let's see. We may just have to have another class on Friday for the sake of Kisumu, maybe a repeat. But generally, it's a topic we can cover in one session, I think. We are not far from concluding it if we decide to do so. So we look at defenses. Okay, there are quite a number, and the one that stands out is defense of what we call prescription. A prescription simply refers to the period of usage. Okay, so you acquire a title by use and time, which is allowed by law. If you continue to undertake, let's say, your nuisance for a long period of time without any interruption, and the minimum that is given by the decision that exists today is for 20 years, then you may use prescription as a defense to allow you continue with your activity without any interruption or interruption from any contact. Okay, and for you to establish your right by prescription, you must be the one, okay, legally attached to that property in terms of use and enjoyment of that property, okay, and that you are aware of the activity you are undertaking, fully aware, in the knowledge of the nuisance activity that you are undertaking, and that nuisance activity, of course, naturally has to be unfavorable to the rights of another individual, and that you claim that for the period that you've been undertaking, at minimum 20 years, no one has come up to challenge or complain about your activity in terms of the impact it's having within or on your neighborhood. Okay, that is for prescription. Basically, it just allows that longer period use without any interference to now pass as a defense. There is also the defense of statutory authorization. What we mean here is that where law exists to give you the mandate to continue with a given activity, then you can use that in court to defend your position and continue with the nuisance causing activity. So when the statute authorizes the doing of a particular act or the use of land in a way, all the remedies, whether by action or indictment or charge, are taken away. Okay. There is also the use of reasonable care. What we are trying to address in the previous question with regard to the smell. If you are able to explain the extent you've gone to take care of your neighborhood, regardless of the nature of the activity you're undertaking, then in most instances, it may not be a defense that can wholly salvage your situation, but it can be used to mitigate a given situation. So if you're able to properly figure out to the judicial officers that you're able to do this and that to curb the impact of the nuisance activity, of course, some may allow you free or accept it as a defense. Others may use it just to mitigate your situation if you are found to be liable. The planning commission, again, similar to use of reasonable care, an award of planning permission does not grant the developer automatic immunity from liability in nuisance, but it comes in handy in mitigating, again, the cost that is likely to follow you if you are found liable in such instances. Okay, that is it for defenses. I think very straightforward, unless for maybe prescription. But still, if you have questions, you may ask. Okay.
Excuse me.
Yes.
Could you kindly pardon on planning permission? I did get it quite well because from the notes, it looks as it is being vindicated. Could you kindly repeat on it?
Planning permission, we have in mind instances where before you undertake the activity that is complained of, the nuisance, before you undertook that activity, you went through certain authorities or required procedures to obtain the permission to undertake the nature of the activity that you intend to undertake. So, for instance, we have plans in our different premises. We have plans for residential settlement. We have plans for industrial settlement, and there are certain authorities that grant you permission to undertake some of those activities. So if you are able to, within strict compliance of those procedures, able to affect again your neighborhood within say in a public setting or private setting, then we are saying it may contribute to mitigating your situation, but not necessarily automatically giving you an indemnity or an immunity from liability completely. Okay, you may have to combine it with probably C to salvage or to get out of the issues complained of. Okay, if you're able to take some reasonable care in addressing the issues complained of and are able to show that you have all the permissions required to undertake this activity from the highest of the authorities that you are required to seek permission from. Okay, so many of such positions just contributes. It does not, wouldn't say, for depending on the situation, wouldn't say it stands as a defense per se, but quite a contributor in terms of mitigation and to the defense also, to a large extent. Have we made any sense?
Excuse me, sir.
Yes.
When you say mitigator, on the on reasonable care and planning permission, do you mean that if this case goes to court, that will mitigate the damages that are awarded, or it will act as a defense? Okay.
Yeah, mitigation largely will have impact on the extent of the awards.
So it does not count as a full defense.
We are hesitant to call it. Again, most of this will be dependent on the circumstances and the facts that is placed before you. It can stand as a full defense if one is able to show, but largely if the facts given by the plaintiff or the claimant, especially in instances where you have strict liability instances, it may not contribute much.
Understood. Thank you.
We go to remedies. I hope I'm not rushing you. I'm trying to see.
Excuse me, sir.
Yes.
What if the act committed was necessary? Can't one plead necessity as a defense?
The last part of your question, if it is.
If the act committed or done was necessary, can't one plead necessity as a defense?
If it was necessary.
Yeah.
I am trying to figure out the situation arising in that under nuisance, probably in a different tort. We in public nuisance we can because if it is in public interest, regardless of the affected rights of an individual, we sometimes allow it to proceed. Maybe you are coming from that angle, not a private nuisance.
Yeah.
Yes, in a public setting, yes, may.
Oh, okay.
But what we are
Thank
looking
you.
at is the private remedies, I mean defenses. Okay, so
excuse me, sir.
Yes.
Before we go to remedies, can you please put some emphasis on the essential on the defense of prescription, where you say that it needs to be unfavorable to the rights of another individual, and then there's no action actionable for at least 20 years.
What did you understand there? That the activity you are undertaking is one affects the rights of the neighborhood, yes, but for the period that you've been undertaking that activity, no party has come out to complain about its impact. Okay. Prescription simply means that by virtue of you having undertaken the same activity, regardless of its unfavorable nature for that period, then no party should be allowed to interfere, to bring. There's an assumption that if indeed you are affected to the extent that you now demand for redress in court, then you ought to have come in good time to seek the court to abet or seek the court to redress or give you the compensation for the damages caused or inconveniences caused. So that minimum period of 20 years is what someone coming with the prescription defense to get away with unfavorable nature or activity within his neighborhood or on his land. Okay, so that's exactly what it means. It may appear a little awkward that this has to remain unreasonable, and yet you are allowed to continue, even on establishing that whatever you are taking is unreasonable. Okay. We will see the difference between the prescription defense vis-a-vis defenses and other courts shortly.
Okay, thank you very much, sir.
So we have remedies. Should we proceed or we stop here?
Proceed.
Proceed.
Stop.
Proceed.
Stop.
We stop.
Right.
Too much of something is poisonous, so we can stop.
No, let's do the remedies.
Mwalimu, let us continue. Someone does
Mwalimu,
let us continue.
You want us every weekend. Want us every weekend.
Let us stop. We have another lesson. Let us digest.
So we can meet next time,
Let's
please.
try and
Please.
finish.
Yeah, thank you.
Let's see if we can finish and then help Kisumu people with our notes. I'll share the notes. I can share the notes shortly after this class. If you have questions, then on Friday I'll be available for your engagement if we'll be able to finish now. I think we still have some 30 or 40 minutes. So agreed. So remedies and nuisance largely fall within these three. That is injunction, abatement of nuisance, and damages. Of course, we are all familiar with the remedy of injunction, which restrains persons, whether natural or otherwise, from acts which might be threatening or invalidating the legal rights of another. So this can be obtained easily in court if you bring and defend, or establish existence of a nuisance against your neighbor. It can be applied both within private and public nuisance. Okay, so the other remedy is abatement of nuisance. This means basically removal of nuisance by the party who has suffered the damage. So this does not require any legal proceedings. It is the affected individual undertaking actions to salvage, the enjoyment of the land or usage of his property. Certainly, this is not advised as such by courts, especially so if the abatement have not been given by a notice. Okay, you need to give a notice that you are going to undertake for removal of this nuisance, so that the other party does not go to court over a different element of tort. Okay, damages, or obviously one can seek for compensation for any loss or injury occasion to the plaintiff by reason of nuisance. So these are the main remedies you can seek under private nuisance. We've said under public nuisance, the criminal element of it will involve penalties. Okay, so largely this three is applied under private nuisance. Okay, question in the remedies? All right. let's go to relation of nuisance to other branches of the law. And we look at the three areas that nuisance relate to. One is the rule in Rayland versus Fletcher. The other one is nuisance and negligence, nuisance and trespass. Okay. So what does the rule in Rayland versus Fletcher state? This, for your extensive reading of this judgment or the reasoning, we'll leave it to you for strict liability engagement, because this is primarily what you will be relying on to determine many of those elements under strict liability. That is not for this lesson. Okay. So what we want to pick from here is the paragraph within that judgment that has been so popularly or notoriously used in many decisions. And the paragraph is the one by Judge Blackburn, which states, the person who for his own purposes bring on his land and collects and keeps there anything likely to do mischief, if it escapes, must keep it in at his peril, and if he does not do so, it's prima facie answerable for all the damages, which is the natural consequence of its escape. The subsequent decisions in this case have extended this escape to mean anything dangerous, including wild animals, including neighbors' dogs, escaping from within your premises to hurt the neighbor, and strict liability has been applied to get redress in court by the affected neighbors. So what is the difference here? So the difference between the two may be summarized as the following five. Okay, so many nuisances are quite outside the rule of Rayland versus Fletcher. When we talk of nuisance, especially in the public setting, we talk of ordinary obstructions of the highway, defective fencing, okay, wetting and setting workmen, and interference with servitudes, those areas that are supposed to be used to access your own public setting. Okay, so naturally the issues complained of under the rule of Rayland versus Fletcher is completely different, because it talks of noxious things escaping, okay, and escape. So, but for nuisance, you don't have to have certain things escaping from the neighbors, the defendant's neighborhood to affect the claimant. Okay? Again, nuisance is confined to injuries which primarily affect the use or enjoyment of land. Okay? However, the rule in Rayland is not just limited to that. It's not just the enjoyment of your land, but any harm that you do on the neighbor land is considered as having caused atrocious act. Okay, so the third one talks of there must be an escape of noxious thing before liability under the rule. Okay, whereas in nuisance we talk of aquatimate injunctions, meaning if there is any danger, impending danger of a nuisance that is certain is likely to be caused by your neighbor, you can go for what we call preemptory injunctions. Aquatimate just means preemptory injunctions, those injunctions that you take prior to even having the actions happen. But for Raylan, a noxious thing has to first escape and affect the neighbors or harm them. Again, it's our noisy background.
Back up, PPP.
This is bad, eh?
Next, Karen Wambua.
Can we have interventions somewhere? Wangi is not yet back. Eh?
Malim, I think from your end you should be able to mute whoever is
Actually, I'm not the host. The challenge is because of your number, we're having ICT people hosting these classes. So I'm not sure whether I'm in a position, but I'm just like any other user.
The ICT guy must be attending the classes too, maybe.
I think we should get someone from our classes to be.
But you are the host now, we can see.
Is it so?
Yeah, you are the host.
Maybe I'm not conversant to it. Let me see if I can with everyone else. What is that? What have I just done? People cannot unmute themselves. Let me hope so. That's dangerous because you want to ask questions. Anyway. We'll see. We've survived. So,
Mwalim, what we need to do is to just tell people that when they start doing the class, they have to mute their mics and unless if you are talking to all of us.
Did I hear you well? You are giving suggestion?
Yes, Mwalim, what I was saying is that, you cannot be watching every one of us, whether he's muting or unmuting, but we make it clear and people get to know that when you join the class, you have to remain muted unless if you want to speak to all of us.
Yes, I think that has been the rule. I don't know why we are unable to follow that. So where are we? At least from where I sit now, the noise is off. So nuisance may be legalized by prescription, as we've seen. This is not applicable to the rule in Raylan versus Fletcher. Okay, it doesn't matter how long the nuisance activity has been taking place in the rule of Raylan versus Fletcher, then you cannot claim to be banking on the defense of prescription to continue releasing the noxious thing to the neighborhood. Again, nuisance, in nuisance, an occupier of the land on which the injury originates may be liable. We should be able to relate this to the nature of the parties we had, who can sue, who cannot. Okay, so what matters is the right attached to the occupier's land. Okay, again, it has been held that unusual sensitiveness of the plaintiff's property to injury is no defense to an action of Raylan, which is in though it will be in action for nuisance. Okay. All right. That is for nuisance and the role of Raylan versus Fletcher. I've indicated earlier. You will delve into this rule under strict liability. Okay. Any question on that? We can proceed with nuisance, distinguish between nuisance and negligence.
Yes, Mwali, on that, on the point that an occupier of the land on which the nuisance originates may be liable. Can you say something about it?
Can I say something about it again?
Yes, please.
The part of nuisance and an occupier of the land on which the injury originates may be liable. We related this to the parties where we said you may not physically be present in that neighborhood for you to be sued or for you to be liable. You may be, for instance, an example we can give is that of a landlord who has rented out his facility, and on his land that is rented out, he has, activities, although he is not occupying the land, he has activities that is affecting the neighborhood. So the tenant may not be liable. The tenant who are the occupiers at the time may not be liable. But in this instance, he is non-occupier, but probably the causer. Okay, he has created the nuisance, even though he is not an occupant on that premise. So in that case, it relates to a nuisance in which an occupier of the land may be found to be liable. I don't know whether it's getting clearer or more confusing.
Better now.
Good. Can we proceed with negligence? In negligence, the plaintiff must prove that the defendant was under duty to take care. Okay, you've done negligence. You've handled the total negligence, isn't it? Okay, and negligence is largely attached to existence of duty of care. But for instance, this may not be necessary as such. Of course, there's the aspect for you to be, it's required of you that you undertake those activities in a reasonable manner that may contribute to mitigation or even were clearly put forward as a defense. But for negligence, the proof of existence of duty of care is a requirement. Okay, which is not the case of nuisance. And again, in negligence, contributory negligence is largely a defense appropriate to negligence, but not nuisance. This I'm sure you are familiar with. Okay, so and many instances of nuisances and of negligence, respectively, have nothing whatsoever in common. Where, for instance, careless surgery may be negligence. And not a nuisance. Obstructing light may be a nuisance, but not, the nature of what you consider nuisance and negligence are well apart, different nature of thoughts. Okay, so that is it for nuisance and negligence. And finally, I hope this is the final slide. We look at nuisance and trespass to land. And there was a question that was it relating to the flooding in the neighbor's land and all that. We distinguish these two as this, that trespass is usually considered to be a direct interference with a person's possession of the land, and it takes place through material object. It means there is no need to prove the damage in trespass. Okay, by virtue of having the object, okay, or the material object onto the neighbor's land, it can be considered prima facie that you have trespassed. Okay, it's visible and it is direct. Okay, while in nuisance, we have a more indirect form of a tort, which deals with the interference with a person's enjoyment of land. Okay, it does not specifically take place through a tangible medium, like for instance, in the case of trespass, you have a material object, okay, that is passing on to neighbors' land, and whether it has had any impact in the neighbor's land is a non-issue under trespass. But here, you don't have to have a physical presence of that object. Okay, it may be just a smoke or just a smell, and if you're able to establish that, then you will be able to go under total nuisance. But if the impact is so direct, there's proof of existence of material object on the neighbor's land, then you don't have to get into details of proving whether trespass has occurred or not. But under nuisance, you have to have enough proof to establish that that intangible thing indirectly has affected your enjoyment of your land. Unless there are questions, I end it there. Thank you.
Hello.
Yes.
Thank you so much. First of all, it's not even a question per se, it's a concern. I would suggest that the next time we probably use a different room. Your room at first, it got better with time, but at first it had a lot of echo.
Okay. This is not okay. Any other observation? Someone is speaking, I can't hear.
Yes, can you hear me? Can you hear me? Can you hear me? Hello?
Yes.
You can hear me?
Yes, I can.
I have like 2 or 3 questions. First of all, there's someone who asked in the chat about having neighbors smoking bang and playing loud music. Is that nuisance or not? And can you sue them? Next one, these guys that
you can say your name.
Sorry?
Yeah, who?
This is Michael.
Yes, Michael, continue.
There are these guys who are interrupting us every now and then when you're teaching us. Is that nuisance or just negligence? Because they can't mute.
Okay. That's all?
Yes, that's all. Thank you.
Yeah, Michael, I don't know whether you signed in late. Can you confirm you joined us at the beginning?
Yes, I was in.
Okay, then there was that distinction we are trying to make between ordinary inconveniences and legal nuisance, or an activity that can be placed within the framework of legal nuisance. So for your last question, I leave it to you actually, for both of your question, I want you to place it within the context of the elements that we have looked at. If you are able to establish existence of a legal nuisance, okay, then you will have a course of action to pursue, depending on the benchmarks that you the context. Okay, we have at some point even indicated even my background and my noisy apparently location here in ordinary usage is a nuisance. But what we are pursuing here under tort is a nuisance that can be placed before a judicial officer for redress in terms of compensation, in terms of all the remedies that we have looked at. Okay? You can appeal if the one that may not even require you to be in court, if you are able to get rid of that nuisance, you are at liberty, right?
Sure, thank you very much.
Any other?
No question, we can end it.
Excuse me.
All right, you've been putting your, sorry, I've not been checking your.
Excuse me.
Yes.
For some who had interruptions or joined the class late, will you help us with the slides or maybe the recording of the class?
Right, I'll promise the notes. I'll give you the not just slides and comprehensive notes on the topic we've covered today. So I think Friday next year supposed to have nuisance on Friday again, which unless you have questions, probably I will allow you to, unless we gather for revision of some sort, I will allow you to have an early weekend on Friday. So
thank you.
Okay, so you, yes.
Do we have a Google Classroom?
Say that again.
Do we have a Google Classroom?
A Google class, I don't have for this class. Personally, I don't have. We are quite a number of us taking different units, topics. So we will be sharing materials that we have of the different topics that we cover with you.
How will you share? On your email, sir?
I will share through your class rep. The person I'm in touch with are your class rep. Kisumu, we've had issue. I don't know whether we'll continue to use Tabitha as a class rep.
Okay.
Yeah, Mombasa has been they even have a page, a taught class page that they normally share those materials, which is very useful.
Excuse me, Mwalimu.
Okay, thank you. It's evening on your side.
Excuse me, Mwalimu.
Yes.
Hello.
Listen to Zendekaya.
Yes, Mwalimu.
Okay, Zendeka.
Yes. Now, you have been mentioning a lot Tabitha to be our class rep. I personally, I don't know this Tabitha. Our class rep is Jen Waiti and myself, not Tabitha.
Oh, interesting. I don't know. How do we get in touch? Can you take my number and then let me, this is important information. Take my number 0722, all right. Is there a way I can?
Let me send you, can I send my contacts on the chat platform?
here. I will exit very soon. Let me do mine.
Okay.
Okay. Is it possible?
If he is not in a position I can take it, I'm picking it for him. I'm giving it to him. Just read out your number.
Hello, sir.
Yes.
Hey, sir. This is the class rep for the Kisumu group.
It's Gladwell.
Yes. No, not Gladwell. No, this is Waiti. Waiti Jen. I'm using Gladwell's machine. We are together.
Okay. Then let
I can give you my contact, please.
Yes, let me have it through Gladwell. I have Gladwell's contact.
Yes.
Yeah, I think that solves our problem. Thank you.
Okay, thank you.
Thank you very much. It's evening on your side. I think I've seen in the afternoon.
Find money.
Anaenda hapa sana na exit.
Send.
Send. Mwambie send.